Alrighty, I would like to call the, what is today? March 26th meeting of the Rules Committee to Sunshine Ordinance Task Force Rules Committee to order at 5:03 p.m. Madam Clerk, would you please call the roll? Item 1, rather.
Yeah, roll of the call. Matthew Yankee.
Present.
Matthew Yankee present. Member Highland.
Present.
Member Highland present. Chair Fiona Hinsey.
Present.
Present. We have a quorum.
Are there any agenda changes at this time?
No, there are no agenda changes at this moment with our agenda.
Okay. What do you call item 2?
Item 2, adoption of the minutes for the October 23rd, 2018 Rules Committee meeting.
Okay, I hope everyone had a chance to look at the minutes. Do I have a motion?
Motion to approve.
Do I have a second?
I'll second.
Do I have public comment on the motion? Seeing no public in the room to comment, Madam Clerk, would you please call the roll?
Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. Motion to approve the minutes passes.
Okay, perfect. Would you call the next item?
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Seeing no public in the room for general public comment, general public comment is closed. Madam Clerk, would you please call the next item?
Item number 4, file number 19008, review and possible amendments to the Sunshine Ordinance Task Force bylaws and complaint procedures.
So we have several issues before us, some of which are new issues and some of which are old issues. We'll go ahead and take these in turn, and at the end we'll take a vote on all of them and take public comment. Then, Madam Clerk, would you please call the first to the bulleted list?
First item, appropriate decorum for members of the public and the SOTF during public meetings.
Thank you. Which item is this? Which item subject matter is this for, Mr. Clerk? I believe
several months ago. Back in December, we received a letter from various secretaries of boards and commissions asking that we take action to curb the behavior of members of the public that was not seen as good. And, there was some discussion about creating rules of conduct for our meetings in general.
And this is this letter?
This letter from various commission secretaries regarding the issue and how they don't want to have to deal with the bad conduct of the public.
Okay. Have my colleagues here had a chance to review this letter? I'm not sure if this was this in the packet?
It wasn't in the packet, but I did recall, and so I brought a copy today.
Okay.
Thank you.
I'll give you
Do you guys need a minute to
gentlemen a
review
minute
that?
to review the letter.
To the chair, question for Victor. Did this letter get in another package of the full Sunshine Task Force at some point?
Yes, it was. It was part of communications on a previous meeting.
Okay.
And the issue was referred to the Rules Committee for additional.
Oh, okay. It was for no.
So it's on the record. Okay, good.
Yes.
Yeah.
All right.
I'll let.
It looked familiar.
Yeah, I'll let you fellows review the letter for a minute.
And another question for Victor. As I read this.
If you recall, you received an email regarding some students who wanted to observe one of our meetings, and they are here. And if you wanted to audio record, that's fine. And if you need audio of our meeting, we can give that to you tomorrow. Yes.
All right. Do they have a copy of the agenda?
Our agenda's right there if you'd like it.
And we're on item 4, and we're looking at the first bullet point. Victor, question for you. It looks like have been meeting to share best practices in responding to sunshine requests. Have these been public meetings? Have they noticed this and agendized this?
I am not part of that group, but since they are all city employees and it's not they're not making any decisions or policies. It's just a group of employees.
All right. Okay.
All right. Do you need another minute or two there, Chris?
Sure, just another minute. Do you have a copy of this for our guests? Okay.
All right. Any thoughts or?
I'm just wondering what, if any, language we already have that speaks to this on our regular meeting notices. Perhaps Cheryl or Victor might tell us what we have, if anything. I'm not sure we do.
We don't have anything specific to conduct on our agendas.
I know in the body of the charter, for instance, 67, I think it's 14, it talks a little bit about recording devices being too loud, etc. Kind of just touches on that. That's one of the things they mention. But I don't think it's a bad idea to have something more comprehensive like this. And certainly we could refer this to the full task force for their consideration and editing as to how we would want to work it into our.
I have a question for Victor. Was this letter just sent to us, or was it sent to? It looks like from the formalizer of the business letter, it was just sent to us. I'm just curious if it was sent to other task force.
I defer to the letter itself. I
Okay.
don't know who they transmitted it to. Just so you know, I would suggest that we have another meeting on this and invite the people who sent us this letter so they can chime in on anything that we may propose. As you know, I did receive interest in scheduling this for hearing, but I wasn't aware specifically that today was going to be the date.
Yeah. Okay. That seems to me to be a good idea.
Maybe we can look around, see what other commissions are doing, and maybe come up with a draft
Right. And
that
then,
addresses all their concerns, and then bring it back and invite people to come back and comment on it. And also a component of that would be enforcement. You know,
yeah.
if the chair is not willing to enforce it, it's relatively useless.
Yeah.
Right.
Right. So how do people, Chris? How do you feel about Victor?
I guess this was reported in our last full task force meeting, and then it came to us for an action. So I guess our action could be to make this an agenda item and at the same time invite the writers of this to maybe our next, because this was, back in December, so we should, I think.
Well, see, I don't know if it should maybe stay in. Well, I don't know when we're going to meet next as a rules committee, but I don't know if this might stay in the rules committee until we get the draft, or should we just put it up to the full task force once Victor and Cheryl have a draft prepared? I'm fine either way.
Yeah, the language looks pretty good, but and I think some of these are already building rules like eating and drinking, signs of content or messages. That's actually come up before us in the past.
Right.
Obviously, profanity. Yeah. How do you legislate for that one? But we have to be careful because we're probably the highest level of free speech. So we want to make sure that nothing in this Ethics Commission template is opposed to what's in our charter. So that
Right.
I think it requires another read, and actually even to have our DCA take a quick look to make sure that this is usable for us and doesn't contradict our charter would not be a bad idea. So I think it needs a more careful reading and maybe a tweaking to our needs would be my instinct.
Would you like to handle it at the next task force meeting, or would you like to keep it in rules committee?
Perhaps we should get it to a draft for SOTF, our version first.
Okay.
So I think between the three of us, we can do most of that work. And even if someone wants to take a stab at it. But I think first step is just a quick run it by the DCA to make sure, to see if his recommendation, if the language is consistent with our charter, and then have someone wordsmith it. And that can all be between, members of this body to Cheryl back and forth until we come to a draft that we're happy with. And then when that's ready, it can go on to the Chair Wolf, to see if he wants to put it on the main full task force committee. And I think we can do that in the background and not have to wait for the next rules committee meeting, which could be 2, 3, 4 months from now.
I agree.
That's kind of my instinct on that.
I agree.
That sounds good.
Yeah, that sounds good.
So I believe you can continue this matter to the call of the chair and it'll be at the discretion of Chair Wolf whether or not he wants to schedule a hearing on the matter.
Okay, I think it's the discretion of this chair to get a SOTF draft of this kind of language to then present to Chair Wolf, and then he can decide whether he wants to bring
So I
it.
believe the motion would be somewhat like to the effect to draft
The SOTF version of this language.
a version of code of conduct language for meetings
Yeah, to be incorporated in future SOTF templates.
to be forwarded to the task force
for consideration.
upon review by DCA COLA and members of the committee.
Yeah, I like
that
that.
sounds perfect.
And at that task force, we can also invite the a subset or members of this group as many that want to show up, that want to talk on it, and some of them may be there for other items anyway. So hopefully not, but they may be. So I was going to say, who'd like to take a stab at a first draft?
Probably should wait for DCI, I'm thinking, to look first and see if he finds anything objectionable to strike out.
Yeah.
I mean, I can send that to Mark in the morning if you'd like.
Okay.
And tell him what we want to do, that we want him to make sure that it's coherent with our charter.
Yeah.
Things like that.
Yeah.
If he sees any nuts or bolts that need adjustment, he can tell me and I can bring them up probably in the May meeting when I do my admin report.
Okay.
Would that make sense?
That sounds good. Mm-hmm. But I'm trying to find someone who wants to take responsibility for then editing that draft.
Do you want the draft to go to DCA Wolf or this letter first?
I think just a note to DC Wolf saying we're thinking of using main parts of this paragraph as our own template. Is there anything that catches your eye that is inconsistent with our charter? Would be the request to him.
And it looks like it references, looks like the Ethics Commission bylaws. Do we have anything in our bylaws that?
We don't have any conduct issues in our
Okay.
bylaws. There are a few conduct issues in the administrative code, which I believe they may already be referencing.
Would this be a bylaws issue then? I mean, if we don't have it in our bylaws, are we? I mean, I
It'll
noticed
be at the discretion of the chair whether or not to add it to our agenda information,
Right.
but I would suggest that we eventually put it into our bylaws.
That might be a good title for it then.
Okay, so for this one, we will. I mean, once that goes through Cheryl and the
DCA Wolf.
DCA Wolf, I'm happy to take a look at it and take a stab at a draft before it gets sent to Chair Wolf to be put on our agenda.
So would you like me to send it to DCA Wolf and have him forward his comments to you? Come up with a draft?
Sure. It seems that if you and he could come up with a draft that I can look at and sort of tweak, that would be
So start with the
Ideal.
first and then get
Yeah.
to you. Okay.
Yeah.
Would someone like to make that motion?
Sure, I'll make that motion.
I'll
What Victor said.
second that. So I'll summarize if you want. So to be forwarded to DCA Wolf for an analysis. DCA Mark Wolf, isn't it? Yeah, DCA. There's lots
Mark
of
Price Wolf, yeah.
lots of wolves in our little world.
We got a pack of wolves here.
Very good.
Literally, yeah. 3 of them.
Is it a pack of wolves or is it a den of wolves? Yeah. Anyway.
Yeah, I think it's 10. Yeah. Anyway.
For analysis to see if it's consistent with our charter, for possible bylaws implementation, forward it back to Chair Hinsey, and then ultimately forward it to Chair Wolf for full task force agenda consideration.
Sure. Is there public comment on that motion? Seeing no public comments, Madam Clerk, would you please call the roll?
Member Yankee?
Aye.
Member Yankee, aye. Member Highland?
Aye.
Member Highland, aye. Chair Hinsey?
Aye.
Chair Hinsey, aye. The motion passes.
Could you add a note, to that for Chair Price Wolf, or not Chair Price, but DCA Price Wolf. I'm particularly interested in our City Hall building conduct directives that are already in place that cover some of this. I've seen this kind of language somewhere. For instance, 67A.1 talks about cell phones in public meetings. That's a piece of it. But I've seen other stuff like signage and that kind of stuff. I've seen that referenced elsewhere. Maybe Victor can help us with that.
We'll look into it.
Yeah, I know there's some other. It might already be covered, and ultimately it's up to the chair. The chair already has the power to say, okay, this is a violation, bring the sheriff up, and et cetera. So I think the chair probably already has the ability to cover these things on a case-by-case basis. I think that's the other side
I
of
think the chair should have some power to enforce basic meeting decorum, but we should probably put it on our agenda.
Yeah, because they're asking to put it on the agenda as well, so maybe.
Yeah, they're asking for it to put on the agenda and be read aloud at SFTs here. And I'm not sure we're going to go that far, but certainly some boilerplate language.
Yeah.
I think
we
is
already
appropriate.
have the disability access thing, so we can just
Added to that.
Added to that, yeah.
Okay, that's all I had.
The
Thanks.
cell phone's already on there too, actually.
It is, yeah.
Yeah.
6-7A. Yeah.
Madam Clerk, would you please call the next bulleted item?
Next bulleted item, parties not willing to attend SOTF or its committee hearings.
We could probably talk about the next two at the same time.
Would you call them together, actually?
Yes, requirements for anonymous petitioners.
And also procedures for authorizing other parties to represent the complainant.
So all three items.
Yeah.
Sure, you can
I
go.
think they're associated, and we can. I believe part of the problem is it's multi-phase problem.
Yeah.
Multiphasic.
We have certain complainants who are generally unwilling to attend our meetings. We need to know how you wish to proceed with that. Will we have hearings without their presence? If we do that, what's the procedure for that? Do they have to say, I want you to have a hearing without us? Is it automatic? In regards to anonymous petitioners, I believe that Chair Wolf is not satisfied with our current standard for anonymous, as when we do receive anonymous complaints, they still identify themselves in the complaint at times. Like they'll give me an email address and their names will appear on their documents. It's very hard to remain anonymous with a complaint. And there are some issues with that. And most anonymous complainants, do they have to show up? Do they remain anonymous when they don't show up? And so forth. And the third part of that is authorizing a third party to represent you. Our current practice is that we need it in writing. One person, I hereby authorize this person to represent me in this complaint. That becomes an issue in that there were some allegations of persons filing under multiple names and then eventually authorizing themselves to represent those anonymous names. So it's multiple areas of concern for your review.
All right. Thank you for that layout.
I just have a question.
Initial thoughts or questions? Yeah.
I was just wondering if there could just be possibly an item on the intake form that says, would you like to attend the public hearing? Yes, no. Or
Currently, we require all parties to attend our meeting because I believe the task force's position is they need the person present in order to ask questions and to get an idea of what the complaint is about. And without somebody there to answer questions, it's difficult to review a complaint.
hasn't the question come up when, with the individual who had the service dogs about whether we should continue without him and whether he authorized us to do so? I was just wondering if we could. I know if it's
Part of it is that we get into arguments over how we should proceed, and I think we should set a standard on what we should do on future complaints. It's a matter of, are they unable to attend or not allowed to attend? Are they willingly not? Do they not want to attend and they want the task force to proceed without their attendance? There's one position from member Josh Wolf is that we should hear the case in their absence because they have the right for us to be heard. But then there's other opinions that we need to be able to ask questions. How are we going to make a decision without being able to ask questions from both parties? So there's a lot of back and forth on these issues. And then I would suggest setting, if you want to change the standard for anonymous filings, you can let us know how you want that to be handled. Do anonymous have to be truly anonymous without their name? We have to redact the names off all their submissions and so forth. But that becomes a problem. When they start doing that, the department can't review the complaint if they don't know who it's from.
Oh, right. Because they can't look for the emails of the. Yeah.
That's something to consider.
This is something I've broached with Nick Cullen before he left us, a little bit with Mark Price Wolf. One of the things we adopted was to allow each petitioner to only have 2 consecutive items at a hearing. By being anonymous, they could circumvent that rule.
That is one of the issues brought up by departments.
Yeah.
That they're bypassing that rule by using different names and filing anonymously.
Mm-hmm. I mean, since we're taking all 3 of these items together, I'm kind of going back to my emails with them. And that's something we adopted in the last couple of years to, try and streamline some of our work.
Thoughts, like Victor said, several issues going on.
Well, if we take the third point separately, in regard, this is a simple one. Do we want to allow parties to authorize a third party to represent them, which is probably a good idea if they can't show up? And if our current practice is acceptable to you, we can put that into our bylaws or our procedures so that we have it written. We currently allow parties to authorize another in writing. But I don't know if you want a more robust requirement or not.
Do we have a time limit that they have to do that, like 72 hours before a meeting? Or?
We don't currently have a time limit on that. And I don't believe we should need one. A lot of times they can't show up at the last moment. It's just a matter of, do you want verification of identities or anything like that?
Again, the standard that we hold is probably going to be higher than any other body in terms of allowing anonymous complaints, free speech, multiple submissions. Our bar is higher than anyone else's, I think. So we have to tread carefully here. And I guess the way we've handled it is ultimately the chair has the decision as to what goes on the agenda. So it's really to the call of the chair is how we've kind of handled all these issues.
I think this part is just authorizing a third party to represent that complaint, either prior to the meeting or during the meeting.
I would say that it's probably a good idea to formalize this practice in our bylaws. And it's probably a good idea to have that as an option for folks. The only problem is, the only disadvantage would be if the person turns up and is not knowledgeable about the case, but one would assume that one's proxy would have briefed them.
I guess. Again, just, playing devil's advocate, I see that as another pretty big door for abuse of the system. Right. That some of the more active people in this room will get someone else to put their name on something they've written, get them to sign off that they're going to represent them, and it's not really another one of their cases, nothing to do with this third party who ostensibly filed the claim. So I think right now we require the petitioner to show up at the subcommittee, at the complaint committee, and the first full task force. Is that
it's just the task force. We don't say first or last.
We don't. Okay.
Yes.
There was a time when we were debating whether, and I'm not sure. I always ask you this. I'm not sure where we landed, and have we ratified that? I guess that's 2 questions. So, what is our current policy on
all parties must show up for all meetings?
Okay. I kind of like that.
Yeah.
And
we got there for a reason,
Right.
Now, is phone an option? In which case, could those
So-
individuals
That
use
might fall in under ADA. So yes,
So in the past,
or anonymous.
we've used the phone as a reasonable accommodation,
Mm-hmm.
which means they would, in theory, for reasonable accommodations, you have to notify us within a reasonable
or as
time period.
or as anonymous. You know,
Anonymous,
you
right.
Right.
Call in and we've done that before. Not very successful. I don't think we could hear them one time.
We've
use it, or-
actually-
They have up to 48 hours before the hearing to let us know if they want to appear by phone.
We've actually, I don't think, ever actually successfully patched anonymous in.
I don't think we had. We tried once
We
5-6 years ago.
Didn't we have one?
It wasn't for the purpose of being anonymous. It was just they couldn't make it to the meeting.
Right.
Yeah.
Right. But I think those options have always been available, and certainly under ADA should remain available. I mean, we should make sure that what we decide on doesn't contradict that. So I'm looking at the first parties not willing to attend SOTF or its committee hearings should almost get the same allowances as anonymous petitioners. And
I believe the part of it that we want to be concerned with is if they're not willing to call in and they're not willing to attend, will we proceed with that hearing or will we close it out?
see, I seem to distinctly remember, and we're going back several years here, Victor, maybe before your time, but I remember people filing a complaint saying everything I'm going to say is here. Please, move forward and serve justice as it, or give me my information. I'm not able to be here, but please proceed without me. So does that become a checkbox? Like, we require all people to attend. However, if you have a disability,
If you want to make that an option for them, it's your choice. If you want to be able to proceed at their request without their presence, without being able to ask questions, you need to be aware that you won't have all the information you may want, and you have to base your decisions on what is currently in the file, and you won't be able to ask questions.
you're kind of giving up your due
Actually,
process,
That
basically.
actually happened with Julian Sarkar.
I think I remember that.
Well, he had showed up previously
He
before,
showed up
but
at all his other hearings, but this was
Yeah,
about redacting documents when
Yeah.
he wasn't present.
yeah. Yeah, nothing to add therefore. It's like, yeah.
Yeah, he didn't.
yeah, but this is just completely paper only, and I know a lot of members of this task force will not be happy without being able to ask questions
Right.
or ask
Yeah.
for clarifications.
I guess the concern I would have, and I think we talked about it a little bit briefly before, is when you said something like the first and last. But if it's one of those issues that gets continued multiple times, that could be, I'd imagine, difficult for some people to come to a committee, then come to the first one. If it gets continued, come to second, third, fourth, or so on, as many times as it may appear. Because I know we've had at least a
It's
few
happened.
times. I don't want to make it such an incredible burden for people to have their, cases adjudicated. They have to keep coming over and over and over again.
Well, don't we?
Right.
I think that right now we give them 2 chances to.
There's not a number involved.
I don't necessarily mean that. I mean, let's say we've continued, like, we need to research this more, or they want to present additional information, or we've stopped before, the.
It's
made
always at their
determination.
discretion. If they don't want to show up and they want you to proceed, they can just ask you to do that. But then again, you're not able to.
So should the rule just simply be, we require you to show up at the first
Right. That's
meeting?
It's your decision to make, but there's always more questions.
Yeah. No, but I'm saying, from a, consider someone that they have to take time out of work to come here for these. We typically require you to show up for the first meeting so we can.
Well, maybe we should
Ask all
say
our
something.
questions.
The complainant may authorize the task force to proceed without
On
their
behalf,
personal appearance. However, they would,
be giving up their due process.
or something to that
Yeah.
effect. However, you won't be able to defend yourself and respond to questions.
So if we say that, how can we then tell them that, no, you can't send someone to represent you.
I think that's always,
You can.
you have one or the other, not both. I think you can do either one. If you don't want to show up and you don't want to, you can either not show up and have the task force review your complaint with your written authorization. I don't want to just, or you can authorize somebody else to attend, or you can call in. But I don't want to put the phone thing out as, and here's another option. It's an ADA issue. It's not.
We don't want to advertise it. So to
Yes.
speak. I understand.
Because, telephone testimony doesn't work very well.
Well, this is kind of my question. I mean, how much of this do we want to get into our
Well, I think
bylaws?
The one option is if they don't contact us, we currently have a rule that if they don't contact us within a certain amount of time and they're not willing to show up, we will just close their complaint because we haven't been able to communicate with them.
Right. What is that number?
I believe it's in our procedures. I don't have the number handy.
I believe it's 2. I'm not.
But then there would be the other option, which would be they would tell us in writing or that I want the task force to proceed with my complaint without my attendance and acknowledge that their whole case will be based on what they provided to us in writing.
So right now, Victor, we don't have anything that covers these exigencies, right?
Yes.
We have some anonymous language, anonymous petitioner language, right?
And there's a little bit more to the anonymous. And what is the requirement for filing anonymously? Do we have to redact all documents?
Okay, let's leave that for now.
Okay.
So looking at the first bullet point, we have nothing to cover that. So let's propose something which we can kick up to the full task force for them to chew over. I think on our intake form, we could say something along the lines of, we require respondents and or plaintiffs and
It's
respondents.
in our instructions, but I know a lot of people don't
Instructions.
read our instructions.
Okay, so that's our instructions, but is that part of our bylaws? Not yet.
I believe it's probably part of our procedures.
Procedures. Okay, and that's really what we're talking about here, right?
Yes, more of the procedures.
So what exactly is the language in our procedures? Would it be on one of the emails? Let's see.
I think it's on each hearing notice, maybe.
It's on page 16 of
Of the attachment. Yeah.
Okay.
This is where
The
the-
packet.
procedures. Okay, in person.
It's like it's on page 18, number 7, kind of halfway down.
All right.
Attendance and requirements for complainant and respondent.
Okay. Unless otherwise provided in these procedures, the complainant and respondent are required to attend the hearings regarding complaints. However, at its discretion, at the discretion of the SOTF or its committees, a combination may be made in response to special superintendent's request made by the complainant to entertain special needs. It should read complainant and respondent because that should be, fair to both. Mm-hmm. If complainant fails to appear without prior communication, the matter may be filed and dismissed without prejudice. Consider closed. Da, 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 da. And I think I thought we talked about if a complainant fails to appear without prior communication of 1 or 2 business days. I know we've talked about that. That language never made it in because sometimes on the morning of, they complain and the respondent shows up, and that's I wouldn't consider that notice. A few hours before. We have certain people to do that all the time.
Well, if we don't receive it 5 days before the meeting, it's not. It's up to the task force or the committee to decide how to deal with it.
No, I'm not talking about part of what's being into the package. I'm talking about cancellation notices from either party.
Oh no, we don't allow cancellations. It's up to the task force how to deal with it. If they don't give it to us at least 5 days before the meeting, we're not allowed to provide an automatic cancellation. It's up to the committee or task force to decide how to proceed.
So let's say we have a full task force tomorrow, and item 4, the petitioner says, "I'm ill, I can't attend." You would then let Chair Wolf know that, right?
Yes,
And you would also let the respondents know that
it's up to the task force to determine how to deal with your request to continue. It's up to the task force. The chair can't make that decision.
okay. So that's why the respondents showed up anyway, and then they listen to what the decision is,
Yes.
and they come back. I understand.
I believe what we're looking at is adding a section C to number 7 regarding authorizing the task force to proceed without their attendance and possibly authorizing a third party to represent them.
Okay.
Adding a section C and D to cover those two situations.
All right.
I wonder if we do this, we should set a time limit for, like, they have to notify us in writing X number of days before a hearing. That way, they can't just, show up with a letter the day of.
Should be 6 days before,
yeah.
so that because we
We
post.
should stick with our standard 5 because that's the deadline for submitting documents
Right.
for the packet. So I can see setting a 5-day time limit for authorizing a third party to represent. But that's also iffy in that I have trouble with setting a deadline to authorize a third party to represent you because sometimes they won't know that they're going to be sick until the last moment.
Or plane flight get canceled or what have you.
Yes.
Oh, okay. See, I think Chris and I are trying to avoid a situation where they just say, "Oh, okay, here's my case, but send another person."
Yeah. I mean,
Yeah.
we have.
Maybe we make sure we send a knowledgeable person to that language and not just any person.
Yeah.
Well, I'm trying to avoid, those people that are active in this room creating.
We can
Focus
set the
cases.
5-day deadline and take a look and see how it works.
Well,
We
we'll talk
can
about
amend
different
this
things.
as often as you want,
Right.
and we really won't know until we try with a lot of this.
Okay. So what we're proposing is 7A and B is there. So C and D, we're trying to add draft language for C and D, right?
Yes.
C being a proxy, basically. To act.
Authorizing a proxy to represent you.
Okay. And D is. What was D? There's two parts to this.
Authorizing the task force to proceed without the attendance of the complainant.
Okay. To act on their behalf. Or just not that's
To
not-
proceed.
To proceed. Yes. Yes. Okay. So.
We can write some draft language and
It could be something like in special circumstances, you may elect someone to represent your case with at least 5 days' notice to the task force. And D could be
we need to give a description of what that authorization would look like.
right. Okay.
So we need to
Or
say
just
that
just
it's
written
writing.
authorization. We could keep it that simple. And D could be assuming the petitioner has showed up for the initial meeting, and the task force is willing to continue without them. They may petition the task force to do so.
That maybe needs some additional tweaking based on what the
Tweaking, but not just don't show up at all, but
they need to tell us.
Yeah, and they need to be aware that they're giving up their due process moving forward, and acknowledge that, something like
So
that.
essentially have the requirement for at least some personal appearance, but
At
not.
least one, right?
Yeah, that makes sense. I mean,
That make, yeah,
Just
that
to get,
make-
like, I don't want to inconvenience people, like you said, work
Right,
issues where it may be
right.
difficult for multiple appearances, but
Right.
And in the case where they're just not willing to show up at all, are we going to hold them to the standard that they need to show up or telephone at least once?
Then we have to look at our next bullet point, the anonymous, because
Yeah.
then they kind of fall into the anonymous
Yeah.
in my book. All right. Or they can say, if they're not willing to show up at all, please see section, whatever it is, anonymous.
We'll look at it, but you waive your
Yeah.
rights to.
Yeah, you'll be considered an anonymous complainant, and our policy is that. Please refer to section so and so and
Yes.
so and so and so. How's that?
that makes sense.
Yeah.
That seems like a good.
It's a good starting point, and
It
we'll.
seems like a good compromise.
Yeah. Just to let them know they're being, considered under those. Yeah.
And then it brings up to the other situation that we had at our last meeting, where what if someone files multiple complaints and aren't willing to show up for any of them? They'll file 20 or 30 complaints and just decide not to show up, and they want us to proceed without them.
well, should we consider some type of vexatious petitioner policy?
We've tried going that route,
We've
and
tried.
we have not been able to. It's a legal term that I believe the task force is not willing to take up.
Yeah, well, that went round and around like a hornet's nest. Again, because we hold a pretty high bar as to free speech and all that stuff. But if we,
But we do have the two hearings per meeting limit, so as long as they're not filing under multiple names, we should be able to catch that.
But if they do file under multiple names,
We have to figure out a way to deal
Yeah.
with it.
I mean, just on the plain devil's advocate on this, if someone does that, then they gum up the system and
We're already
prevent
gummed
other
up.
people. Yeah, right. I mean, so
if we go back to that, if we just say, right now our policy requires all complainants and respondents to show up to every meeting. That's your baseline.
Yes.
That stops, multiple spurious or false name, things, because they got to be there for the first one. If they can't do that, then that dies, and everything behind it dies also.
So that would be if you require that they show up at least one meeting and don't allow for.
The task force to continue with that item or other of their items unless they show up. I think each item should be taken separately.
Yes,
they
yes,
need
you can
to
do
show up
that.
at for each item to progress
So
through the
we-
process. They need to show up at least the first meeting.
So
they then have an option to, yeah.
So in essence, we will require that they show up at least one meeting. There's some objections to that from other members, but I'm sure you will work it out among yourselves once you get to that point.
Can't wait. Okay.
And then
Because
if
right now our language is every meeting, right?
Yes.
Or just all meetings, like what it says here in 7.
attend hearings. So presumably that would be all.
It doesn't specify whether it's complaint committee or full task force or compliance after the fact. It just says all hearings.
So I believe what we're getting down to is we're going to write something to the effect that as long as you attend one meeting, you can authorize the task force to represent you the rest of the way, or to hear it without your attendance.
I'd like to throw in some language. I like the language that we have: attend all hearings.
Yes.
Boom. I think as option C, at the call of the chair, you may petition the chair to allow the task force to continue on your case if you're not able to attend. I like that they understand it's a special circumstance, not that it's 7C, I can do that.
Yes.
So I
At
think
the discretion of the chair, they may
You may.
do this to accommodate your needs.
yeah, or you may petition the chair to accommodate your special needs. Obviously, ADA stuff is separate, but
Okay.
and you realize
We will play around with it and bring it back to you. It's just
okay.
a lot of ideas. We'll play with it and come up with some good ideas and send it back to you for
Yeah.
review.
Okay. All right, so that's a starting point.
Is that including adding a respondent to item A?
Yes,
But
it
I
should.
think I think that's a good idea.
And actually, I was looking at this document, and I can give Cheryl's, at the end some edits, but I think we need to comb through it carefully to make sure the language is consistent. We flip flop quite a lot between the city and respondent. I think we should take all reference to the city out. It should just be respondent.
Yeah.
Just for cleanliness, so might just do a search and replace on that as one thing. That happens quite a lot in there. And while I'm on the edits, there's one last thing. I think in the last page. Yeah, so just do search and replace on city for respondent would be great. The other one will come to me. I'm not sure what it was. Okay, so back to the bullet points. So I think we have some working language now for the first bullet, right?
Yes.
Victor, can you remind us what do we have for anonymous petitioners, or maybe Yankee knows what page this is on? Let me do a search on that.
I think it's probably under requirements.
I see something on page 17, number 5. Public openness and anonymity. All submissions are considered public records and are open for public review. SOTF will accept anonymous complaints. However, please note, SOTF will not redact submitted documents unless mandated by law, which means, what if there's a...
I'm not responsible for finding your personal information and getting rid of it.
Right. Unless it's like a part of
medical record or something like that.
Or an active court case or something, maybe.
I wouldn't know that.
You wouldn't know that, would you? Okay. All right.
It's the responsibility of those submitting the documents to redact anything they consider confidential. It's not up to me.
Okay. So the assumption is it's open and public.
But I believe Chair Wolf has issues with how we handle anonymous complaints in that their name appears all over the complaint, and anyone who looks at the complaint knows whose it is.
Yep.
So what's the purpose of filing anonymously? If you want to file an anonymous complaint, let's go all the way or not do it at all.
Okay. Just devil's advocate, could the complainant strike out their name and send it in? Sure, they could, right? And make a
it's just the nature of what we do. It's kind of hard to file a complaint without being able to identify who the complaint is from. It's just the nature. I asked for a record. Well, in terms of records requests, unless they made the request anonymously in the first place.
The IDR, for instance.
Yes.
Yeah.
Right.
And then how would the department have filed it if they...
Otherwise, the department can't identify which complaint it is. They won't be able to respond. They would have to be anonymous all the way through the process in order to remain anonymous.
And then they come to us and a complaint, and they remain anonymous. So technically, they can remain anonymous, but they have to. The onus is on them, not us. Mm-hmm. Whatever they give us is open, it's public.
Yes. And then if it's something not related to a public record, it's a lot easier. A public meeting or something to that effect, it's a lot easier to be anonymous, but not with a public records request.
Which is it? I got you. Okay. Mm-hmm. So I'm not seeing language on, other than that, on how we...
I think Chair Wolf is concerned on our standards for filing anonymously are too loose. Just to take person in general, we'll just call them person A, always files anonymously, only for the purpose of not wanting his name to appear on our agenda and not trying to remain anonymous. So his name is on every single letter he writes. It's on all our packets, but he still insists on filing anonymously. I believe that's the main person that there's
I mean, that's his right.
he's not really
Well, if that's the case.
he's not really anonymous because
Well,
But if that's how he wants to be...
if that's how he wants to be identified on our agenda.
if that's your opinion, that is acceptable to me. Is when it gets to the full task force, it'll come down to a vote on. The problem is there's different opinions among all our members, and I'm just trying to portray that
Can you give us a past case number on that?
We can.
I
We
mean,
will
right-
send it to you.
right now. I'm just curious to see.
Give me a moment.
I think it's,
Go ahead if you have one. You have a number.
I'll just go to the ODs and I can point it out to you.
Yeah.
Go to our website.
This isn't the guy who, this isn't the person who filed anonymously due to ADA issues, is it?
I don't believe so.
Nice. I never knew this was here. Shame on me.
Oops. I hit something by accident. Oops.
Right there. Chrome.
This one?
Okay.
Let's go to 2018.
Use this if you want. I hate that keyboard.
This is for the public's knowledge. This is case number 17082. Anonymous versus Luis Herrera and the Public Library. This was heard on by the board on November 1st, 2017.
17082. In the body of it, it's there.
Yep.
Yeah. And the fact that he writes a letter in his name saying that he wants to file an anonymous complaint, I now understand Chair Wolf's dilemma. Well, I think maybe we need to develop an anonymous section. It looks like we don't really have one. Do we?
No, we don't.
Okay. So in
Maybe a different application form for those who want to file anonymously.
that would work. And on that, the very first thing you should say is anything you supply through this portal or through this document is open and is a public document.
And if you identify yourself in the documents,
You will be identified in your item.
in your discussion and during open public meetings and so forth. And, you know, if you write it down, we can't avoid reading it and saying it out loud.
Okay. It's yeah.
Yeah, this is odd because they say it, but once they say it and put their name, now it's no longer anonymous. So, yeah.
Yeah.
That brings to the question, what is really anonymous and what isn't?
So I think it should say, I mean, that should be the first part of that section.
A definition of what anonymous is and maybe a definition of what we consider anonymous and the requirements for filing anonymously.
Okay.
Just set a criteria of what we consider anonymous is, and if you don't meet that criteria, we can't accept it anonymously.
Right. But and it should say in order to maintain your anonymity, your original IDR should have been submitted as anonymous, because we will discuss that. If you want to remain anonymous, the onus to not use your name or identifying information is on you. Anything you provide us will be open and public record.
Mm-hmm.
I mean, I'm thinking also regards to email address. I mean, obviously we need a way to contact them. So if they, a lot of people have their name in their email address. So I don't know, do we want to say, be advised that the email address that you provide us will be public? We could. I mean, so maybe they want to go on Yahoo and make I don't know, but do we encourage?
We need to create a criteria
Right.
addressing all these issues on what we need to consider a complaint anonymous. Right. Otherwise, we can't accept it as an anonymous complaint.
Mm-hmm.
I believe that's the direction Chair Wolf wanted to go.
So guidelines for basically being anonymous.
I'm just thinking at a minimum we'll need some type of you'll need some contact information for them, right?
Yes. When it comes down to it, we can keep the email address redacted for our office use only.
Mm-hmm.
I do that for the Rules Committee all the time, but we need to create our own process and work with it. So I guess we can write something up on our minimum of what we want to consider something anonymous. We can bring it back to you. This is not a urgent matter, but it's something that we should eventually address.
Okay. I mean,
create an anonymous criteria to be inserted into our procedures.
I like something as brief and general as, we do accept anonymous complaints. However, any information you supply us, any identifying information you supply us, will, as a matter of course, become a public record. Please talk further to our clerk as to how to maintain your anonymity. I mean, that...
And we do need to have a list that us as administrators can go through.
Can go by.
Otherwise, we'll have people insisting, we need something in writing to tell people we have to follow this procedure. Mm-hmm. Otherwise, they'll insist that they don't have to, or...
Right. I see what you're saying.
Yeah,
to help
you need something that you need a net to cover your...
Yeah.
So we're trying to take the burden off the administrator so that we don't have to make up things as we go along.
Right.
But we'll work on something and we'll get it back to you.
And who I think member Josh Wolf brought up something about, and it may not be appropriate, relevant here, but what's the new Prop 8, whatever that passed with the privacy? Is that...
I'm not sure about that one. I think that's still pending passage.
Okay.
But I am not aware of the details of that.
Yeah, because that might be contradictory to... That might also guide or trump, how public our records going forward. I think that we talked about at the last meeting about it being secondary, or it was there was some language in there that probably...
We'll try to get a copy and look it over.
Yeah. I think we all need to familiarize ourselves with that anyway. Fortunately. Okay. So just...
So I believe we will be writing a couple of new items or a new sections, and we'll provide it to you for review. And it's probably best to schedule it for another hearing on a future date to work out the details before sending it to the task force. As we're starting from scratch, and we will distribute and schedule.
So we will continue this item. All right.
The motion's to continue the matter.
So, do I have a motion?
Sure, I'll move to continue the matter.
Sure.
Of the chair.
Do I have a second?
Second? Second, yeah.
There's no members of the public in this room at this
There's
time.
no members of the public in the room for public comment.
So I believe you can adopt that without objection.
Thank you. All right, Madam Clerk, would you call the next?
The next item, bullet point.
Yep.
Next bullet point, SOTF member excused absences.
And just so you know, the last item on the agenda is kind of a repeat of the items we've just talked about. So this is our last item for discussion.
Okay.
And just to give you a summary, we brought this up a few years ago when the Chair Wolf originally came back. As you know, there's a requirement that after 2 absences, it doesn't matter if it's excused or not, we are required to notify the members that they've missed 2, and if they miss another one, we need to report them to the full task force. To the Board of Supervisors for possible action. I believe what we want to do is create a description of what an excused absent is so that it doesn't count against that 2 or 3 per year. Mm-hmm. The problem we had in the past was what is an excused absence? And we couldn't come to an agreement, so we left it alone as any absence, even if there's a valid reason, counts towards those 2 or 3 per year. I believe the thinking is that we want to come up with a standard of can we excuse anybody for an absence and for what reason?
So I have a question for Victor. Since you clerk for the Board of Supervisors, so were we to come up with, what is an excused absence, and were we to adopt a policy of, okay, this is an excused absence, this is not, would it be okay with the board if we then adopted our excused absence policy, i.e., would they not count what we consider to be an excused absence as one of our absences?
I'm not sure. This is in our bylaws. Let me take a look at the code section.
Yeah.
In our bylaws, let me read what we have. Section 2, attendance.
Yeah.
Members of the task force shall notify the task administrator if she is unable to attend a regular meeting of the task force. That means a full task force meeting. The administrator of the task force shall notify any member who misses 2 regular meetings in any 12-month period of time. This is page 10 of our policies and procedures. In any 12-month period. Okay, so that's a rolling 12-month period of time. If a third or subsequent absence from a regular meeting occurs, the chair of the task force shall notify the Board of Supervisors of the member's lack of attendance. This has happened in the past when I've been on this body, and nothing happened in the sense that the Board of Supervisors noticed, but I think they then talked to the chair, who gave them some more information, and basically no action was taken. We're going back about 5-6 years. We were short on people, and it was deemed in the interest of not removing that person to keep the meetings going, I think was the...
I don't see anything in the Sunshine Ordinance that sets this rule. I believe you impose this rule upon yourself.
Right, I'm looking at the ordinance itself on 6730, subsection E. It just says, shall approve bylaws specifying a general schedule for meetings, requirements for attendance by task force members, and procedures and criteria for removing members for non-attendance.
Yes.
So it sounds like the
You
2
impose that on yourself.
and the 12 months is nowhere to be found in the actual ordinance.
Yes. Self-imposed, so easy to change.
Right, that's what it looks like.
Where is that again? Remember, Yankee?
That is
67.36.
6730, section E.
Okay. It just says shall approve bylaws specifying. Okay. A general. Got it. Okay.
So if you want to change this to something,
I mean, I would read that as giving us leeway to
Yes,
distinguish
you can-
between excused and unexcused.
Right.
just a matter of determining, coming
What
up with
is
a
it?
definition that everybody can live with.
Right.
I'd like to work some to the call of the chair rather than the chair shall language in there, because there might be pretty good reasons, and I'm not sure if we can come up with numbers of okay, you can have one excused and two non-excused, and then we have to or one excuse for every non-excuse. But ultimately, I think the chair would have a good idea of that member, whether they're really pulling their weight, whether they're, there's, outlying reasons that that particular stretch of time they couldn't be there, surgery, out of the country, whatever it is. So I'd like the chair to have the ultimate say on
Whether he deems they deem it an excused absence or not.
Yeah, exactly.
Basically.
Now, the other flip side of that coin is that everything will be, appealed as an excused absence, and then it might increase our absentee rate, which is not good either for the work that we have to do and the necessary votes.
Right.
Given
And
the quorum.
you may want to give the task force itself as a whole some authority, because what if the problem is with the chair, it's themselves?
True, although
True. One would hope not, but that's true.
But
We're just
it's
talking
forward
long-term.
thinking. Yeah.
Yeah.
Because I believe this initially came about because there was one member who was continuously absent. There was no contact with this person at all, but we couldn't remove them because they were sitting on the term. So I believe they created this to give the task force an option to ask the Board of Supervisors to remove this member
This is going back some years now.
many,
right?
many years.
Okay.
I think that's how this got started. It hasn't been a problem. Well, actually, we do have a problem with one person now, but
yeah.
that's multiple, not just,
Yeah. I still don't understand how that name is still on there, but anyway.
yeah.
yes. Unless he resigns, he's still a holdover, and I can't do anything about it.
And well, let's not even get into that. Anyway.
Yeah.
Okay. Our member emeritus, I guess. Whatever
So that's kind of the situation of how this came about, so that we can report it to the board, and the board has the authority to remove that person because they are the appointing authority.
Okay. So let's take a stab at that, our internal
If
policy.
I apologize, I need to take off, but I believe this one is easy enough to develop a new policy.
Yeah. It's there.
And of
is
course,
this-
we can talk about it some more. And
We will consider this an excused absence.
Yeah.
and just so you're aware, the biggest problem when we had before was nobody could agree on the definition of excused,
Right.
and that's why we left it alone.
So, okay. Here's what I recommend, and I've got some language to capture the chair as well at the end. But I think, let me pop open that language that we do have. Okay, so members of the task force shall notify the task administrator if she is unable to attend a regular meeting of the task force. Task force administrator and the chair. I'd like that to read. That's my first edit.
Yeah, definitely.
This is page 10, Article 2, membership and attendance, page 10 of our bylaws.
Yeah, I would agree with definitely.
Because I'm trying to drive towards this going to the call of the chair.
Yeah.
I lost my spot. Where is it? Okay, tenants. So, and the chair, if she's able to attend.
Okay, Section 2, attendance under Article 2.
You got it. So, members of the task force shall notify task manager and the chair if And then we can insert a line saying, the chair or vice chair, let me think about this. I'm trying to put the vice chair in there as well in case the vice chair has to call out the chair on whether it's an excused absence or not.
Yeah,
I think that's a
There needs to be some type, just
Yeah,
catch,
there
I
needs to
think.
be some kind of check on the
if
chair.
they're both in
too.
cahoots, then good luck to us
Well,
all.
yeah.
But I think that'll at least put that in there, so that not so everyone's beholden to the law. I think.
well, couldn't the
How about the acting
entire
chair?
task force by majority vote
That
go against what the chair decides anyways, and so
Okay. Actually, that's. So what we could do is the thing is I also don't want to air our dirty laundry on absences.
Right.
So I don't think it should have to go to a vote.
no. I'm saying, but you're right. If
Yeah.
we thought it was going down a improper path, there's a way for the task
I
force
think.
to jump in.
I think. Here, I'll just think out loud. A member who's not able to attend may appeal to the chair for to be excused from a meeting. The chair will rule on that. If the chair needs to be excused from a meeting, the vice chair will rule on that.
Yeah, and the task force, obviously could always
Yeah.
overrule the chair if need be. But I think that's good language.
Yeah.
That gives everyone a
Yeah. Not just yet. Let's just flesh it out a little bit more, but we're getting there. So notify the task manager and the chair to unattend regular meeting of the task force.
Should it be the chair and vice chair, or should we? I'm back to your first sentence. Just in case the chair is absent himself, then we.
Yeah.
Or should it just remain with the task force administrator, who can forward it to the chair and the vice chair?
No, I think that actually, you know what? Maybe the language is better. So notify task force admin, chair, and vice chair if he or she's able to a regular meeting of the the chair or vice chair will determine whether this is an excused absence or not. Period. Then we can go back to the language of the administrator of the task force shall notify any members who misses 2 regular meetings in a 12-month period of time.
Should we change that to 2 unexcused absences? Or,
2 unexcused absences. That's fine. Just to kind of let them 2 unexcused absences or 3 excuse or 3 missed meetings. Because I think if you have 2 excused and 1 not, you're still racking them up a little bit.
well, at that point, couldn't the chair decide we're not excusing it? Wouldn't that be settled at that first
That's
stage?
true. That's
They could say, look, you're missing a ton. We're not excusing them
Okay.
anymore.
I like what you were thinking. Okay.
Yeah.
So administrator of the task force shall notify any member who misses 2 non-excused.
Yeah, unexcused.
Inexcusable.
Yeah.
I think non-excused meetings, non-excused regular meetings, right, is the language we
Yeah.
want. Non-excused. Is there a dash?
Is it?
Like
Any member
any member
who misses
who misses 2 regular meetings
that were not excused, there you go,
There we go. Yeah.
in
There we go.
any 12-month period of time. And then here's language. Yeah, it's true, because if it's the call of the chair whether it's excused or not excused, then anything that's not excused follows. The rest
Exactly. Then we can just follow this
the rest
kind
of
of
it
as
holds.
written. We just basically just switch out,
Yeah.
misses with.
If a third or subsequent absence that was not excused from a regular meeting occurs, the chair or vice chair, because you have to have the vice
That's right,
chair.
yep.
The chair or vice chair may,
Well, at that point, maybe it's a shall.
maybe, yeah, I think
Because
shall.
at that point, the
It's too-
discretion has already been made whether it's excused or not excused.
Very good. Shall notify the board of supervisors of the members' lack of attendance. Good. That was hard.
No, I think that covers it. I like that.
Do we want
Do you
to?
want me to refresh that for you, Cheryl?
Do we want to set a timeline as to when they can? I don't know, for lack of a better term, petition for a excused absence.
Nah, I think when you That's why we're putting the language. They have to let the chair and the vice chair know at that time. You say, I'm missing. I mean, you can just say, I'm not showing up. Fine. That's not excuse.
Right.
You can say, I've got to travel for work,
Right.
travel for death in the
Have a
family.
surgery, right? I mean, whatever it may be.
Surgery, I think all those things would probably fall into discretion.
Right.
Ooh, don't know about that one. What about vacations been scheduled, but they're free because you want something anyway? Getting punchy right now, but yeah. So I think what Member Hinsey's getting at is, should there be a reasonable time period that can allow, because
Right.
if, let's say, 3 people decide a few days before, this all came up, then we can't hold a quorum. It would be nice. I think for an excused absence, you should know, unless it's for medical reasons.
Right. I mean, if you're in a car accident that morning,
Yeah,
that would be excused, but there wouldn't fit a time.
Right. So I think maybe we can insert a language like, aside from medical excuses, other requests for excused absences should be presented to the chair or vice chair at least 5 business days before.
I'd actually feel more comfortable with something like
Longer?
No, just something like as soon as possible or something. Because I mean, there's even stuff that's not medical. I mean, let's say you were stranded and we had to go in the Midwest, right, for business trip.
Right.
Tuesday, here comes a snowstorm, and you can't make it back from Minneapolis.
Yeah.
Right. Right. I mean, there's earthquakes, there's hurricanes, there's a whole bunch of stuff that may be, again, with that. I mean, I think if we leave it a little more vague as possible, the chair or vice chair, I think, can make that determination of whether or not it's truly
Ultimately, if someone comes up with something last minute that seems like it should have been notified earlier, they can say, sorry, this is not, you've left us in the lurch. We have we're already down a member for that meeting. We're not considering this an excused absence. So they still have that purview. Maybe we can put in language like, is it expected that members will notify the chair or vice chair in as much time, in as much advance notice as possible for excused absences aside from circumstantial or medical, or except for medical or circumstances out of their control. But just to say that there is...
well, yeah, I think, having that type of expectation is good. I would just be hesitant to actually call out specific categories.
Yeah, it's hard to say.
I think that's what the chair, vice chair would determine. Is that one of those categories where they're just being abusive with it, or is it legitimate? I mean, that's part of what we're entrusting them with, I think, to make that judgment.
Right.
So I think that's why, I don't want to block ourselves into,
Okay. I think maybe that's inherent in their decision of.
I think so. That's what I'm saying. I think we can trust the chair or vice chair to use reasonable judgment in doing so.
All right. Okay. You want me to summarize it one more time, Cheryl? I think you got it. Okay. So, attendance. Members of the task force should notify the task administrator, chair, and vice chair. Insert that. The rest of that sentence is good. Okay. The chair... no, wait. I lost it now. Or the member may appeal to the chair or vice chair
to have their absence excused.
To have their absence excused. Actually, I think cleaner. The chair or vice chair will determine whether the absence is an excused absence.
Yeah, I don't think it needs to be an appeal procedure. I think you're right. Just
so the chair or vice chair will determine if the absence will be an excused absence. Period. No. So we got the first sentence down, right? Okay, got that. Next sentence.
Unable to attend regular.
Okay, next sentence. The chair or vice chair will determine if the absence is an excused absence, period. Will determine so that is an excused absence. Is an excused absence. Okay, next sentence. Whenever you're ready. The administrator of the task force shall notify any member who misses 2 regular meetings that were not excused. Who misses 2 regular meetings in any 12-month period of time that were non-excused.
Not excused, I think, yeah, that's good. That we're not excused. Just add that to the end of that sentence. I think we're good.
Yeah. So the second sentence, or what's now the third sentence, stays the same all the way to the end, and just add on there that were not excused. No. Nope. Just as it is. I know we've gone back and forth, but we're doing a third pass of this.
The administrator of the task force shall notify any member who misses 2 regular meetings in any 12-month period of time
that were not excused. Cleaner.
Yeah.
Hold on one second. Hold on. If a third or
I would recommend putting after occurs on that, or where you're at now, that was not excused, and then...
Yeah, but shouldn't we also put a timeline? Are we still staying in the 12-month or an 18-month, or right? Because we referred to that in the sentence before.
I think 12. I think keeping everything else is fine, and then just say, oh, I see what you're saying. Oh, I see what you're saying. The third or subsequent absence from a regular meeting occurs
in that same 12-month period.
In that same 12-month, yeah, that was not excused in that same 12-month period.
Okay. So if a third or subsequent, if
a third or subsequent absence from a regular meeting occurs
in that same 12-month period,
that was not excused.
Okay.
I want to say a third unexcused absence.
Okay. Well, we're reading absence as not excused. We're reading excused absence as not an absence.
Right.
Oh, I see.
Right.
Okay.
So we don't have to say that, right?
Does it misses? Probably should clarify it. I don't know. It says,
Okay, let's put it in there. So, Cheryl, that last sentence is going to read, if a third or subsequent non-excused absence from a regular meeting occurs in that same 12-month period. Sure. Non-excused absence. All right. Sorry. Back up. I'm going to make it cleaner. If a third or subsequent absence that was not excused. That doesn't read right.
I was going to say, if a third or subsequent absence from a regular meeting occurs
That was
in
not,
that same 12-month period that was not excused.
Very nice. What he said. Say it again.
So if a third or subsequent absence from a regular meeting occurs in that same 12-month period that was not excused, comma, the chair
The rest of
or
it.
vice chair
The chair or vice chair.
of the and then the rest, yeah, as it is.
Sounds good.
Good. Wasn't so hard. Yeah, we batted that around in the full task force and 10 people trying to wordsmith it.
Yeah. No, you can't have that many people trying to Actually, I think that's really solid language.
I think we're good with that. I agree.
So are we
All
on
right.
to the last bullet?
Did you want to read it back just to make sure? Like the whole entirety? What do you think?
That's a good idea.
Members of the task force shall notify task force administrator if she is unable to.
No, I thought, what was that? I thought it was going to be the task force administrator, chair, and vice chair. And, right?
Shall
Yeah.
notify the
Task force administrator, comma, chair, comma, and vice chair, if she is unable to attend.
If she is unable to attend a regular meeting of the task force. The
Then the next
administrator of the
sentence.
task force shall notify any member if a third or subsequent absence,
No, we're
second sentence,
right. Shall notify any member who
member who misses
misses.
2 regular meetings in a 12-month period of time.
That we're not excused.
I think you have to get it from the audio, Cheryl, because I think we got it in the last pass pretty
Yeah.
clean.
Yeah, I have a note on there to
Oh, you
check
do?
the
Okay,
tape.
okay.
Yeah, so I'm going to check the tape. Before.
Okay.
Okay,
Oh,
all
then
right.
we're good.
Yeah.
All right.
All right. So, can I get a motion
Sure.
to move that?
With edits to move that for review by the full task force.
I'll second that.
Seeing no public in the room for comment, Madam Clerk, would you please call the roll?
Member Hinsey? Chair
Aye.
Hinsey? Chair Hinsey. Member Yankee?
I
Member Yankee, aye. Chair Hyland? Member Hyland, I'm sorry.
Aye.
Motion passes.
just as an addendum, we should probably make sure that the chair and vice chair has everyone's contact information and vice versa. Like,
I think they do.
okay,
Through the clerk.
no one ever gave it to me being new. I've seen yours and Bruce's on various communications, but I don't have his phone number. I don't know if you would want to text or you know.
Should I create a list of
I
like
mean,
phone numbers?
because even this morning you're like, is it, you know, or this
Well,
morning, earlier.
technically, our communications to each other should go through the clerk anyway. So, so that's
Right. So should we then? I mean,
but it's already in there, so you have to let the admin know. And
All communications are, it's seriatim if you don't do it like BC.
right. Okay. So I'm just looking at the first sentence when we say members of the task force shall notify the task force
But yeah, but
administrator.
if we want to like
Chair
text the
and vice
chair,
Yeah, like if I have to tell Bruce. I mean, I think I have his number in my phone. Or I'll email him.
I'm then saying, let's pretend, you know, I'm in a car accident. I can't come in, right?
Right.
I obviously have your contact. I can send you an email. Say, I'm been in an awful car accident. I'm in the hospital. I can't make it. The way that we have that phrased, adding chair and vice chair, would I then also, should I be texting Bruce?
Let me and I'll let Bruce know. Let me know. And I will
but he's
communicate.
talking about what we should have in there.
We said shall notify the task force administrator, chair, and vice chair. Now, how can I?
Let's take it out. You're right.
Yeah.
Because we,
Yeah.
I was trying to put it in just to make it keep the language consistent, but we introduced the chair and the vice chair in the next sentence.
Right.
So
It's
that's
there.
fine.
So I just want to make sure that wasn't incumbent upon some person to reach out proactively and
Yes.
text the chair and vice chair
Maybe-
themselves.
That would be
Maybe-
I thought it was
responsibility.
right. So that's why I was, if we're adding, so let's
Right. So that first sentence stays as is,
So let's keep that as is and take out chair and vice chair because you're right, they come in later.
and then the language is consistent. Yes, that keeps our consistent.
Do we need to re-vote on that? Or is-
Well, who's the maker of the motion?
okay. I'll move to modify.
You can move to as amended.
Move to as amended.
Move as amended.
I accept, a second I accept. Can we take that back, Mason?
Sure.
All right.
Call the last bullet for formality's sake, but Victor says.
Last bullet, the complaint committee requested that the issue regarding the requirement to attend committee hearings be referred to the rules committee for discussion.
We talked about that, didn't we?
We talked
Yeah,
about
he
that.
said that we already covered that.
I'm
Yeah.
just
Okay.
calling in for formality.
And so, for the record, we're maintaining our current
Yeah.
policies on that, which state that complainant and respondents are required to attend all meetings.
Okay. Yeah.
So that would include complaint committee.
And so, seeing no public in the room, to wrap up public comment on the whole of this item, public comment is closed. The next item is adjournment.
Adjournment, and it is
6:39.
6:43.
Make a motion for adjournment.
Second.
Sure.
Slam that gavel.
Oh, right. There you go.
Done. All right.
Okay.
That was good, guys.
Yeah.
Yeah, we got